5 seconds to go. Start. The issue which arises before this court is whether the High Court was justified in granting bail to the second respondent. The offence in the present case involves the alleged murder of a young child for ransom. The trial is proceeding, though, in our view, it would be appropriate to direct that it should be completed expeditiously. The High Court has primarily granted bail on the basis that the charge sheet having been filed, the custody of the second respondent was not required for the purpose of investigation. PW3 is an approver who has not supported the case of the prosecution, and the case rests on circumstantial circumstance, and at this stage there is insufficient evidence to indicate the involvement of the second respondent. The High Court has, while granting bail, failed to notice crucial aspects which have a bearing on whether or not a case for the exercise of the jurisdiction to grant bail under section 439 of CRPC was established. Since the trial is presently underway, we are not entering upon a discussion of the material which has emerged during the course of the investigation which led to the filing of the final report under section 173 of CRPC, or for that matter of the material which has emerged during the course of the trial. However, an important circumstance which should have but has not been taken into consideration by the High Court is that crucial witnesses are yet to be examined. The release of the second respondent on bail at this stage would run a grave risk of impeding a fair trial. The apprehension of the appellants and of the prosecution that the witnesses may be tampered with cannot be regarded as lacking in substance. Considering the nature and gravity of the offence, the role which has been attributed to the second respondent, and the crucial witnesses which remain to be examined, the exercise of the discretion by the High Court in the present case is improper. The appeal is accordingly allowed, and the judgment and order dated 2nd March 2022 of the single judge of the High Court of Delhi in bail application number 196 of 2022 is set aside. The second respondent shall surrender forthwith. Since the trial is pending since 2014, we direct the trial judge to conduct the trial expeditiously on a day-to-day basis and to conclude it preferably within a period of 1 year. The appeal is allowed in terms of the signed reportable judgment and the judgment and order dated 2nd March 2022 of the single judge of the High Court of Delhi in bail application number 196 of 2022 is set aside. The second respondent shall surrender forthwith. Since the trial is pending since 2014, we direct the trial judge to conduct the trial expeditiously on a day-to-day basis and to conclude it preferably within a period of 1 year. Pending application, if any, stands disposed of. Stop.